Hello everyone, welcome to our recorded lecture for Module 10's discussion of advertising regulation. This is Professor Hooley, you're in COMMS 300, and thank you so much for your patience with this different format. We have a lot to talk about today, and so I hope that you will be able to follow along. And if you have any questions after watching and listening to this lecture, please reach out to me or to our TA so that we can provide any additional detail that you need. Okay, I know we have a lot of advertising students in our class, and if we were together, I would have you raise your hands and identify yourselves. It's a really popular, in the law we would call it a practice area, but I guess in communications we call it a discipline, right? Or an emphasis in our school. And I just want you to think about whether or not advertising is speech that is protected by the First Amendment. So let's back up and let's remember that the First Amendment protects speech from government regulation, from government censorship, with some specific exceptions that we've talked about in our class so far. So until the 1970s, really, there were not any constitutional requirements on government's ability to regulate advertising, or, as we'll call it, commercial speech. The government could really do what it wanted because advertising wasn't really considered to be an important part of public discourse or an impact on society in any way. But today, I think that we have a different perspective on the impact of advertising. So think about your opinion and your experience with advertising campaigns. Does advertising affect its viewers? What do you think? Now, I can come up with a few ad campaigns that I think have been a positive impact on viewers. We have ad campaigns about all sorts of social awareness, environmental awareness efforts. A lot of our car ad campaigns now focus on some kind of green practices and positive environmental either manufacturing techniques or these hybrid cars that are available. What are some other positive advertising campaigns that you can think of? There are a lot out there. There are also a lot of negative advertising campaigns out there. And a lot of the ones that come to mind historically for me have to do with nicotine advertisements, tobacco. I mean, you think about the fact that we had Camel advertising with a cartoon camel to try to attract more smokers. Well, what kinds of smokers, what kinds of potential smokers are really being targeted by those advertisements, right? Children. Because who else would really respond to an animated camel? So I think we can all agree that advertising affects its viewers, especially those of us who've chosen this advertising profession. It's not something that we just are doing to sell a product, although that's important, and to please our clients, also important, but we want to have an impact on the world. So it's those negative ads, those potentially harmful ads, that made it necessary for our government to start regulating commercial speech. And we started historically with the Federal Trade Commission, the FTC. And they wanted to define deceptive advertising. That was the advertising they were targeting that they felt was harmful, was the advertisements that deceive consumers. So this FTC test should show up in your outline because it is black letter law, and this is definitely going to be tested on the final. But don't worry, I will show you, after we get through this PowerPoint presentation, I will show you a really handy flow chart that you can use on the final exam that has this test included. So you don't need to reinvent the wheel unless retyping this in your outline is helpful for you. So the FTC sought to define deceptive advertising with these three elements, these three bullet points. And yes, you need all three. It's like a checklist. So you have this representation, omission, or practice. Usually that's the ad, but it could be something the ad's not saying. And we'll come back to that in a minute. And this is likely to mislead that reasonable consumer. We're looking for that unicorn of a reasonable consumer. And this representation or the omission of information is what we call in the law material. It means it makes a difference to whether or not this consumer is going to buy this product. Okay, so remember on the final exam, if you tell me these bare bones elements, you will earn points. But what we're looking for is a demonstration that you understand what they mean. So these next few slides are going to give you some more detail about what these elements actually require. So this first notion of having a representation, an omission, or a practice, we can be talking about things that the ad expressly claims. We can be talking about things that are implied. And we can be talking about things you don't disclose with some limitations. I mean, you don't have to tell the consumer everything about your product in one advertising spot, but there are a few things that you really have to disclose, like secondhand products. You have to tell your consumer that they're not getting something brand new. This point about a reasonable consumer is just like with all the other situations we talked about. It's really important because yes, it's okay to slightly exaggerate, right? That's what we call puffery, which is such an outdated term. But really, we expect that as consumers. You know, we know that those cheeseburgers don't look as good in real life as they do in the picture. We know that the Coke pouring over the ice cubes is not as delicious and fizzy as it sounds and looks on the screen in the movie theater, right? But we have to look at what the reasonable consumer would expect. And this experience has to make a difference to whether or not the consumer buys the product. So here's an example that I use in a lot of my classes. Let's just pretend that I, Professor Hooley, am obsessed with a specific color, let's say turquoise, and that the BYU bookstore has advertised a special on new iPads. And if I buy a new iPad at the bookstore, I will receive a case, a cover for that iPad in either black, white, or turquoise. Being obsessed with turquoise, I, of course, march right over to the bookstore and I want to buy my new iPad with the turquoise cover. Now, there's no fine print in this ad about while supplies last or, subject to availability. There's nothing like that. And they're out of turquoise. And I'm so upset, right, that I file a claim with the FTC. So let's back up. Let's look at these elements. Where is our representation, omission, or practice? It's the statement that says, hey, free turquoise case with purchase. Okay, there is no turquoise case. So let's go down to the third one now. Was this color material to my buying decision? Yes, that's why I went there, right? It's the only turquoise cover in town. That's why I went. But the tricky part is the second bullet point. Is that likely to mislead a reasonable consumer? Well, do you know any reasonable people who are so obsessed with a color turquoise that they're going to file this kind of a claim if they don't get their cover? No, most people would say, hey, I'll take black or white, or can you let me know when you get a new shipment of those in, or something, right? But most of us are not so color obsessed that our whole world is going to be rocked because this color is not available. So that's what we're saying here. We have to be looking at our reasonable consumer. Now, the next issue historically that our courts tackled was, how do we even define what commercial speech is? okay? And so in the flow chart I will show you at the end of this PowerPoint, that is really one of the first questions that we ask. Are we dealing with commercial speech here? Is it speech that's worthy of some kind of First Amendment consideration? And is the government allowed to regulate it in any way? So we have two different tests for whether or not something is commercial speech. Now, the first test that we'll talk about is called the Bolger test. And if you look at the date, 1983, it's old, right? But it's a United States Supreme Court case, which is the ultimate law of the land. So it's a case that we still talk about. It's still good law. It hasn't been overturned. But the test we'll talk about on the next slide is newer, okay? It's from a state court in California, but it's newer. So we actually usually talk about both of these tests together. So let's talk about this older test first. And I think you'll see fairly quickly why we use a newer test, because a lot's changed since 1983. That was the time before the internet, before smartphones, before social media, before this kind of hybrid, like influencer, collaborator, advertising world where we're seeing a lot of ads that promote a product, but it's not as clear-cut as it used to be. Hopefully that makes sense. So in this old test, these are the elements under Bolger. Was the ad or the speech paid for in a traditional advertising outlet? Well, traditional usually looked like a newspaper ad. It looked like a radio spot, a banner on the side of a bus, right? Then we ask, does it reference a specific product? And is there an economic motive for this piece? So usually the answer is yes. But now think about the last time that you were scrolling in your feed and you saw some kind of an update from an Instagram influencer. Do they pay? Does someone pay for that spot in a traditional advertising outlet? Well, under the auspices of this test in 83, no, right? Because Instagram didn't exist. It's not a traditional advertising outlet. But number two is also important, because when you're looking at these, we'll call them, I don't know, like, hey guys, updates, I don't know what to call them. We know, because we're not naive, that they're selling us something. But do they always reference a product? Sometimes they do. They'll talk about how they have a discount code or that's a sponsored post, and sometimes they don't, right? And then, is there an economic motive? Well, probably, but it's sometimes unclear what that motive is, right? Who is actually getting paid? Who is the sponsor? Who is paying whom? Is it a collaboration between a brand and a spokesperson where there's no money actually exchanging hands, no economic money, right? But there's still benefit. So you can see how Bolger doesn't really fit all of our situations today, which is where Kasky versus Nike comes in. Bolger is a narrow definition of advertising. Kasky is more broad. So look at the year on this case. It's a 2002 case. It is a California Supreme Court case, which means it's persuasive to us in Utah, but it is the trend. It is kind of the current standard. So on the final, you're going to want to address both of these tests and see how this test actually encompasses a lot more speech that's advertising that we encounter today. You've got this commercial speaker, so that influencer definitely is commercial, right? There's some kind of money being exchanged somewhere. Do they have an intended audience of consumers? Yes, the followers, right? And then, is there a message with a commercial purpose? Yes. So on the final exam, you're going to want to talk about both of these tests. Okay, but the biggest question of all is about whether or not it's constitutional for government to control advertising. So if it's not deceptive and it's commercial speech, is the government allowed to control it? Obviously, if it's deceptive under the FTC, yes, the government can limit that speech. But if it's not deceptive, so there's nothing wrong with the speech, is the government still allowed to control it? And that's when we talk about a general constitutional issue. Okay? This test, the Central Hudson test that you see here, is a classic constitutionality test. If you go to law school and you're talking about whether or not a government regulation or law, if it's constitutional, this language is going to come up again. It's going to feel very familiar to you. What we are looking for is that the government show a substantial interest or reason for the regulation, and that the method that they choose accomplishes the purpose that they're claiming to have. Finally, that regulation has to be very narrowly tailored. It has to fit like a glove according to what their purpose is. It can't scoop up too much speech in this limitation, okay, in this regulation. And we're going to talk about an example here in a minute. This is a lot to take in, so let's just walk through an example. Okay, let's go to our module here, and I'm in student view of our class. Okay, so the way that I typically get there, I either scroll down on the home page here and I go to module 10, which is advertising regulation, and here in module 10 we have this handy decision tree for commercial speech regulation. It will lead you to this PDF. I highly recommend that you download this PDF and you insert it into your outline. You are allowed to use this on the final exam if it's part of your outline. Okay, I'll say that again. You may use this flowchart on your final exam as long as it's part of your outline. Okay, so let's zoom in and you'll see how handy this is, because it just leads you through all those tests that we talked about. Now, on this flow chart, we start with whether or not it's commercial speech that we're dealing with. Okay? Always answer yes, because on the final exam, the TA and I are looking for you to demonstrate what you know from our class, how well you understand. Okay, if you stop here, let's say that you determine that we're really not dealing with commercial speech, then we're talking about these other First Amendment standards we've already discussed, like incitement or Shank. Is it expressive speech under O'Brien? Right, we're dealing with other types of speech. But on the final exam, it's going to be commercial, because I want you then to be able to talk about this FTC test. Is it deceptive speech? Right, deceptive advertising. We understand that yes, the government may regulate deceptive advertising. Okay, it has no First Amendment protection, as it says right here. It's harmful, so we allow our government to regulate it. But look, on the final exam, you're just going to keep following these arrows, because I want you to engage in this constitutional analysis, which is right over here, Central Hudson, right here. Does the government have a substantial interest? Is the method effective to accomplish the government's purpose? And is that method narrowly tailored? Okay. Now let's go back and talk about an example, because as you know, that's my favorite way to help you prepare for these tests and to understand what we're talking about. So the easiest way for me to show you is to go back to module 10 here, advertising regulation, and with your handy decision tree open in another screen or printed out for you, however you're going to use it, let's click on this link that's called Extra Practice on Advertising Regulation. The cool thing about these questions is that they are taken from actual cases, okay? And that there is an answer key linked right here. So let's start together with the first scenario, Let's talk it through, and then you can look at these other ones on your own and see if you understand how your analysis stacks up against my answer key. If you can understand how to get from your answer to mine, if you understand why yours doesn't quite match, and then you're able to course correct on the final exam, you're in great shape. If you don't get it, that's when you need to contact me and or the TA to have some extra explanation. So let's look at this first classic example. This scenario 1 actually comes from this Central Hudson case, okay? Central Hudson is the name of that test, the constitutionality test that we were talking about. So this is where that test comes from. So if we were together in class, I would ask you, has anyone ever been in a major metropolitan city in a blackout? This case is about an energy crisis in the 70s in which the state of New York, so that's our government actor, there's our government regulator, our potential censorship situation. New York State decided to completely ban all advertising by electric utility companies that promoted the use of electricity. And the reason, their purpose, was to prevent that advertising from causing an overconsumption of electricity that would make this energy shortage worse. Okay? And then this we just help you with here. There was no reason to think that the ad was deceptive or that it was related to crime so that the government would otherwise be able to regulate. Okay? So let's go back. Let's pull up our decision tree and let's walk through the analysis together. Here we go. Advertising regulation, decision tree, and let's start. So remember, on the final exam, I want to see a regurgitation of these black letter law elements and an explanation. The great thing about having this decision tree here is that it's done for you, and so you don't have to guess. Okay? So first, we would ask ourselves if the speech is commercial speech. You can go through this, and a lot of the details about whether or not it's in a traditional advertising outlet, we don't have that information for our example. So we'll just assume yes, and we've already told you in the question that it's not deceptive. So we keep moving to get to the Central Hudson core constitutional analysis. Here we go. Does the government have a substantial interest in regulating this speech? So think back to my first question. Have any of you ever been in a metropolitan area during a blackout? Some of us in classes have been in like New York or DC when there's no power. Let me just tell you, it can be kind of a scary experience. As you all know, I lived in Manhattan for quite a few years, and once I was seeing a movie with some friends and we lost power. So a place that is usually very brightly lit, the whole city, suddenly becomes completely dark. And this was in an era of smartphones, so we had flashlights on our phones, but in the 70s, most people didn't carry a spare flashlight, right? And so you have to exit the theater in the dark with all these people and then somehow make your way home. But subways are powered by electricity, right? Traffic lights are powered by electricity. So even just walking, it could be a very much more dangerous, crowded experience to get you from the movie theater to where you were ending up. And then let's say you were living in a high-rise, or you're there vacationing in like the Marriott Marquis in Times Square on the 50th floor. You walk up all those stairs, right? Your key card doesn't work because there's no power. And one of the most interesting things to learn about emergency preparedness in a big metropolitan city, you don't often have room to store food and other non-perishables, but then you also can't access your money, your cash, because where do we access our cash? The ATM that doesn't have power. So if you really just wanted to get out of the city, you would have no cash. So, okay, what is the government interest here? the government is looking to preserve order and safety. Anytime we're dealing with health, safety, and welfare of citizens, the government has a very strong interest in protecting those things. So if it's about safety or welfare, we're going to say that yes, there is a substantial interest. And that's the case here. Yes, there's a substantial interest. You want to protect people. Where we get hung up is on these last 2 points. Is the method chosen by government actually effective to accomplish the purpose? So what's the purpose? The government wants to reduce energy consumption and keep people safe, right? So these blackouts don't keep happening. Well, is that really going to be accomplished by banning all advertising for electric utilities? Think about it. When you turn on a light switch, when you turn on your air conditioner, if you have a window unit or you have central air, are you influenced by advertising for electric utility companies? No. Like, who is? Who? You just turn on the light, right? If you need a new air conditioner, you go buy it because you're so hot. So the question really then becomes, is this a smart move by the government? Is this the most direct way for them to accomplish their purpose? In this case, no. It's not effective, okay? It doesn't accomplish the purpose of keeping people safe by limiting these ads. For purposes of the test, though, keep going, because then I want to hear your thoughts about this other point. So this method, right, they banned all utility electricity advertisements in the state. Is that method narrowly tailored? Meaning, does it only scoop up the slimmest amount of speech possible to accomplish the purpose? Or does it gather in too much other speech? Okay, all electricity utility companies in the whole huge state of New York, think about where the suck on the power grid's coming from. It's Manhattan, right? And really, what is drawing most of the power? It's those air conditioners. They are brutal. Here in Utah, most of us have central air, and so we haven't experienced the magic and the frustration of dealing with window units, okay? They are brutal on your utility costs and so necessary because it's hot and steamy there, right? So when everyone is blasting their air conditioners, power goes out. It just happens. So how could the government have done a better job, right, of pulling in not too much speech here? Well, maybe they should have done some research, right? Where is the usage coming from? Hopefully their research would have shown it's Manhattan air conditioners. So maybe we regulate advertising for new air conditioners in Manhattan. Do you see how that's a more narrowly tailored regulation? It catches much less speech that actually will fix potentially the problem. So these folks up in Albany or Saratoga or wherever in New York, they can still experience electric utility advertisements, although who does, right? I don't even know what that is, but whatever, it's the 70s, without having that speech limited. So we're looking at alternatives. This analysis requires us to use a lot of our brain and a lot of our understanding about what is going on in the world and in kind of the environment when we're talking about this situation. If you just state the black letter law and you do your best to apply it to the situation you have in the final exam, you know how it goes. You're going to get points, and that's great, right? But the more that you explain what these elements mean and the more artfully that you apply them, the more points you're going to get. So that, my friends, is a lot of law that I just left you with. And I'm hoping that you allow it to soak in a little bit. We will talk about this next time. We will do more of these examples together. And just download this decision tree. I will show you again where to find it. It's in the modules, Module 10, under Advertising Regulation. Here we go. Right here. Okay. Decision tree for commercial speech. And the extra practice is helpful. As always, the course guidebook is helpful as well, that PDF overview. Now, not to freak everyone out, look where we're at. Module 11 is next week. Okay? Broadcast Internet regulation. It's kind of light on the black letter law, so it really yields itself more to a 10-point question, as does Module 12, which is after Thanksgiving. Then we are done. We are done. And we have final exam and all of your other assignments that are due. So, please let Abby and I know if you have any questions. Again, thank you for your flexibility and participating in this recorded lecture. And I look forward to reading your diversity paper next week and any other assignments that come in. Thank you so much and have a wonderful, wonderful week. Take care.